Yo, it's your boy DZ. If you haven't already subscribed to the channel, hit that subscribe button, hit that like button, and share this video. Alright, well, the YSL case is going to do a hearing today. So they're going to have a hearing today on, I guess, with the other defendants that took a plea deal because their cases have been separated. So we're going to see what the hearing is about when it comes on. But I'm sure as the world is watching this case, this gives you an insight of the justice system. This here is opening up what goes on inside the justice system. And if you see, even if you think Young Thug is guilty or not guilty, this is not a fair proceeding. This situation here is not a fair proceeding. So regardless if you think he's guilty or not guilty, we all deserve a fair trial. Nobody deserves to be handled this way. The procedures are the procedures, but what you see is when it gives them room to break certain procedures, they do that. But the trial's been going on for about 6 months now. And everything just looks fishy in the situation. But I'm gonna click the trial on. And at the same time, I'm gonna commentate on some things. But these are the co-defendants that took plea deals that are in the courtroom. It's gonna be a different kind of hearing today. You know, it was 28 people in this case. You see they lined up all around here. These are, out of the 20 people, I think it was like 20 people that took a plea in the case. So these are the people that took the plea, and everybody took a plea. Took a plea saying that they were willing to testify that YSL is a criminal organization and they committed crimes in front of the gang.
About that right now.
This is the YSL clip that all turned on Thug.
Okay. Okay. So we was right. Yes, I know. But they're right.
How I call about it.
You need to now, the first one
he's biased in this situation. I don't know if he has a personal problem with the defendants, but the state usually sides with the prosecution. You have to have overwhelming things on your side for the judge to go with you. Just like one little reasoning to believe that you're guilty, they're letting everything in that they want to let in the case. I'm sure all these guys was in the video that Thug made, Take It to Trial. They was screaming, take it to trial. People like want to be a part of things that they're really not ready for. Being involved in the streets leads to you in court with a criminal case. And don't nobody want to think about it until they're in that situation. They're thinking about what they're gaining at the time, the excitement that they're having at the time, but the outcome is this. These are the results. If you know better, you'll do better. These are the results, though. This is basically a witness hearing. That's what this basically is. Because these guys are witnesses. Unless some of these guys haven't took pleas, because there were some cases that were going to be separated, that they were going to go to trial separately. And I think this guy right here talking to the lady with the glasses on, he had a hearing in court, and he told the judge that I'm not taking the plea. And the judge was telling him, I would recommend you to take this plea because if you take it to trial, you have to be sentenced. And he told the judge that he wasn't taking the plea. So I'm thinking that there's guys in here that didn't take the plea. These are just the co-defendants that are now on trial at this hearing. Or they could have all took a plea. But I just think for me, watching the hearing,
Court will
remember
now remain seated.
that the guy
Court will now come to order.
he wasn't going to take a plea.
All right, good morning, ladies and gentlemen. My name is Alford J. Dempsey, Jr. I'm a senior judge with the Superior Courts of the state of Georgia, and this is the final plea calendar for the YSL 7 defendants. I'm going to go ahead and call the calendar, and by this time, they have been updated. Offers that may or may not have been the same or different than what may have been previously made, but they have in fact been made, and defense counsel was instructed to discuss it with their clients. And as I call the calendar, we'll hear what, if any, announcements are being made, whether there's a plea, whether there's a further notice to the trial calendar, or whether or not they need a moment to confer with the state and the defense counsel further before an announcement is ultimately made. So, all right, everybody, I need to have it quiet in here, okay? No chit-chatting and all of that. Thank you. First case is State versus Miles Farley.
Morning, Your Honor. I'm Stassis Medina. On behalf of Mr. Miles Farley, we'd like to please be further notice to trial hearing.
All right. State have any announcement to be made with regards to this defendant?
No further announcement, Your Honor.
Your Honor, may we be excused?
All right, just 1 second. Is this, as I understand, that whatever the offer was is no longer available as of today?
Yes, any offers that were made will be withdrawn after today, if not accepted.
Okay, then Mr. Farley is further notice to the trial calendar. State's offer is withdrawn. Okay, and you may be excused, sir, with you and your client.
All right, thank you, Judge. Good to see you.
All right, good to see you too. Have a great day.
Thanks, you too.
Next is
That's somebody
State
going to
versus
trial. They didn't take the
Garlington.
They said they're
Good morning,
going to
Judge.
trial.
Thomas Mandelli for Mr. Garlington. On this case, Your Honor, the state conveyed an offer in writing, which I've conveyed to my client. I've spoken with the state as well. At this point in time, we are declining their offer. The case will be further noticed as a result, but per discussions with the state, we would like to be able to keep negotiations open.
And today is the last opportunity to make a negotiated plea. Anything after the delay is going to be non-negotiated, regardless of whether the state or the defendant has negotiated something. We put this on the calendar a good while back. This case has been going on since God created Adam. And so if you haven't worked out something yet, too tough. We just moving it to the trial calendar. And that's all I've got to say. So you had plenty of time to talk about what could be done,
He's not
and
yes.
that's it. So further notice to the trial calendar, state's offer is withdrawn. Anything after this is non-negotiated.
That's fine, Judge.
He
Thank you.
said,
You're welcome.
No more offers after the day for a plea. If you don't accept this plea bargain today, that's it. There's no more negotiations after the day. He said the trial's been going on as long as Adam and Eve. This judge
State versus Adams.
is watching the trial also, and he sees that it's a lot of funny stuff going on.
We'll do a pretrial. Come back to you. All right.
Judge,
Yes.
can we make sure everyone is on the mic?
I'm sorry.
Can we make sure that all speakers are on the mic or at a mic?
Okay. Were you able to get the last statements? Ms. Jones, were you able to get the last statements?
Yeah, she was very low, but I did hear her. I just
All
want
right.
to make sure.
All right, folks. Court reporter is on the Zoom, and you'll need to be at a microphone that's actually working. I think that one might not have been working. Is it?
So as we see
All right.
in this hearing, though, it's some people in here that haven't took no plea, and
No, she got. Ms. Jones said she was. It was difficult to hear, but she got it.
one
So,
of the defendants, that lawyer, that
all right. Damone Blaylock.
for that guy, his name is Miles Farley.
Good morning, Your Honor.
Good morning.
We received an offer from the state. I have reviewed that with Mr. Blaylock. At the moment, he would like to reject that offer, and we'd be asked to please be further noticed for a trial calendar. There was, I'm sorry.
Go ahead.
There was one other thing that I wanted to just discuss with you. As I notified the court that I had filed a motion in reference to Mr. Blaylock's severance from the original trial. An order on that motion was filed on May 10th, if I'm not mistaken. I did request a hearing on that motion. I never received notice of that order until June 11th. I filed a motion requesting that the Honorable Court please reconsider that motion and allow me to be heard on that motion. There were some things that I did want to bring to the Honorable Court's attention to at least put on the record. So I would respectfully ask the Honorable Court if we could please set that for a date, and I could be heard on that motion. Yeah.
Okay, no. I decided it based on the brief. The defendant cited no authority for the proposition that the court was required to have a hearing on the motion. And so the facts and the circumstances that on the transcript from the proceeding were clear, and therefore there was no merit to going back to allow defense counsel to be able to orally argue a meritless motion. Second thing, we filed it in Odyssey. And from what I understand, your information is correct. So that's what we're supposed to do, file it, and it's supposed to go to counsel. Well, I don't know why you didn't get it, if in fact you didn't get it. But the more significant is the fact that Ms. Chavis, the case manager, emailed you a copy, and you didn't file a motion until 11 days or thereabouts after you actually clearly had notice of it because you got sent to you. And then the Superior Court rules, if you want to make a motion for reconsideration, you got to do it within 10 days. So even if you didn't get it under the normal Odyssey process, you had more than 10 days before you filed the response. So it was untimely. But, you know, this is, with apologies to the Four Tops, this is just the same old song. And it wasn't good the first time. So with no disrespect intended, I'm not going to just take up court time to allow somebody to come in to argue a case when the pleadings clearly make, and the facts aren't really in dispute. Therefore, that motion for reconsideration is denied.
Okay, Your Honor. I understand.
You further notice into the trial calendar, correct?
Yes, Your Honor. I just put just a few things on the record just for purposes of Mr. Blaylock.
Yeah, go ahead.
Just as it pertains to that motion, I did want to say, so again, that Mr. Blaylock did not consent to his severance originally.
Which is in the original brief.
Yes,
go ahead.
Correct. So generally, the trial court is allowed to sever an individual if, upon a motion by the defense or the state, that it could be granted on that basis. A motion to sever was heard on behalf of all the defendants in this case earlier, which was denied. On this particular day, neither Mr. Blaylock nor the state raised a motion. Both of us actually opposed. Mr. Blaylock and the state opposed that motion. There was no finding of manifest necessity by the court. There was no facts that the Honorable Judge Glanville laid out to indicate manifest necessity on this particular day. The only information that Judge Glanville put was that it served his best interest. To be quite frank, I'm pretty sure it would serve everyone's best interest to be severed in this case. However, there were no factual findings of manifest necessity, which is what is required for a trial judge to sever a defendant. There was no facts. There was nothing pertaining to the actual evidence in the case that was laid out as to justifying Mr. Blaylock's severance. It was simply that he fell ill one day. He wanted medical treatment. Mr. Blaylock and I offered to waive his presence, offered an alternative to being severed. The Honorable Court denied that and elected to sever him despite his discontent with that. And just ultimately, there were no factual findings. There were no findings based on the evidence being confusing, being prejudicial to Mr. Blaylock, and no finding of manifest necessity by the court justifying his severance without his consent. That's all I have to say on that, Your Honor.
Question, what, if anything, you just said now that you didn't put in the initial brief?
I put most of that in the initial brief. just the reasons that people generally have motions. I'm sure that when we come in here and I'm able to orally express certain things to you, I'm sure that I can not only have a chance to respond to what the state says, but also I can answer any questions that you may have, frame things in a different way, rather than taking up paper, putting everything in a written brief. So that's really why I wanted to be heard, just to, really be able to flesh out some things and answer any questions that you may have. If the Honorable Court stands by his ruling, I completely understand and I respect that. But I did just at least want to be able to put some things on the record.
Okay, well, let the record reflect, you just argued the motion and you haven't said anything that's going to change the court's mind. And so the motion is denied. All right.
Okay. Okay, Your Honor. Thank you. May we be excused?
Yes, sir. You can. We've got so many defendants in here. We'll have to, in an orderly fashion, allow different defendants to be excused at the time that is most convenient and safe for the sheriff to handle that. So, but you may be excused. So have a good day.
You too, Your Honor.
Yeah, I mean, he's not been doing his job. They got other things going on, and he's defending here the people that they separated from the case. So,
Who is your attorney, sir?
he said he don't even know.
Oh, Mr. Lalum. Okay. All right. Yes, sir. I think we received an email from Mr. Lumumba, was it yesterday sometime or whatever, indicating that he had a family emergency and needed to be at the hospital with his father, was what we were told. I think the state was actually sent a copy of that email as well. Ms. Hilton?
Yes, Your Honor. It looks like, are you here?
I am, Your Honor. My name is Attorney Kareem Cashman. I've been the.
Would you get on a microphone for us, sir? And would you come on, man? I'm trying to do the best we can. Yeah. All right. That's fine. We will see what's what. All right. All right. Yes, sir.
Morning, Judge. As I was saying, my name is Attorney Kareem Cashlin. I'm the newly appointed attorney for Mr. Cobb.
This is Mr. Fleetwood.
Well, that's half the issue.
Ms. Jones, did you get counsel's name? So I can have him spell it for you if you need to.
So I see, I apologize.
Your Honor, it appears that Mr. Luemba is the attorney on position number 5 and number 8, who would have been Justin Cobb. And so it appears that Ms. Cobb, okay. Sorry.
Okay, well, we haven't got to him yet, so you can have your seat, okay? All right. Your attorney that's assigned to you, now whether or not y'all have had any in-depth discussions or all of those kinds of things, I hear what you're saying, and you're indicating that you don't even know who they are, and I appreciate what you're saying, all right? He isn't here today, so we will deal with that as appropriate. Let me say this in response to what you just raised, sir, as well as in general. Anyone that's paid any attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for the whatever the name of that organization is that I never can get these initial kinds of things straight, but when a request is made for an attorney to be appointed to represent a defendant, it takes forever for them to get somebody and put them in place, which means that it does take time for the attorney to come up to speed and to actually be able to communicate with their clients in order to properly prepare to handle a particular cases. There's been this case has been going on so long that certain defendants may have had one attorney, then somebody left the PD's office, or somebody left the Georgia, whatever they call them, counsel of defense lawyers or whatever it is, and then somebody else has to be appointed and then come up to speed and all of those kinds of things. Well, that's what we're dealing with. So what we do is the best we can do. So if somebody hadn't had a chance to adequately prepare, or they aren't properly representing their client, then we do what we need to do to make sure that that doesn't affect the ultimate result of the case. So he's not here today because he has a legitimate emergency. Now, whether or not he's talked with you, met with you, or prepared with you previously, I can't deal with that, and I have no reason to doubt what you're saying. But as far as what we can do today, his father apparently is in the hospital, and unless we've been told something that's not true, and I don't have any reason to believe it's not true. His father's in the hospital in a very serious situation, and he's there with his attorney there. We'll look further into the idea of whether or not he's adequately been prepared or been with you to do what he needs to do to represent you in this particular case. So that's the best I can tell you right now. Now, if you want to, you may want to hear what the rest of what's going on. If you would, you can stay. If you want to step out, then we can do that now if the sheriff is able to do that. Okay.
Yeah, see, they all on this case, and the case is messed up. Like, there's things going on in different directions. You know, the attorneys are getting placed on these people, and they're not even coming to see them. They're being signed. Yo, you have this client. You have this client. Because there's so many of them.
He just keep his final plea open, given that his counsel wasn't present today.
Yes.
The jail system, the attorneys, everything is messed up there. Their system is out of control. You can see this judge here, he's like the type of judge that is straightforward. Like, man, I know things are messed up. I know, he even said, I know that the system is behind when they're trying to get these clients appointed attorneys.
Okay. Next is
he said the process is messed up. How they
State versus McMullen.
But that's their process.
Come on. If you, yes, please.
Please.
Good morning, Judge. Attorney Lim here for Mr. McMullen. I don't have discovery yet. I am going to get it in different phases, but as soon as I get it, I'll do my best to get this case ready for trial.
He doesn't even have
You were just recently appointed.
Yes, Your Honor.
Did you not? Well, that's what I'm saying we're dealing with. Guess we'll hold this one open as well to allow. Let me see, what do we got for? Okay. All right, Mr. Lim. Then we'll leave it open, and you can continue to come up to speed.
Yes, Your Honor. May I be excused?
Yes, sir.
Judge, can we get him to stay and spell his name for me, please?
Yes. M-E-N-G, last name L-I-M.
Thank you.
Thank you, Your Honor.
Yes, sir. Jarvis Bradford.
Good morning, Your Honor.
Good morning.
Attorney Aisha Braddock for Mr. Bradford. An offer has been conveyed by the state, and Mr. Bradford is rejecting that offer at this time, and we would like to be further notice to trial.
All right.
Thank you.
Further notice to trial,
All
calendar.
the people here that are there because their case was separated, they see that the YSL case is all messed up.
Okay, now we're on Mr.
They
Cobb.
would be dumb to take a plea now. They see that their star witnesses are not cooperating.
Morning again, Your Honor. As mentioned, I'm Attorney Kareem Cashlin. I was recently appointed on the case not even a month ago. I've yet to receive discovery. Additionally, I have yet to receive a plea offer from my client to even convey to him. And critically, Your Honor, unfortunately, I have been unable to get in contact with my client. I don't believe he is necessarily absconded from the court's jurisdiction. I believe it's more of a clerical error in that the conflict office has not given me proper contact information. So I'll have to go to the clerk and ascertain that info for him.
Your Honor, Mr. Cobb has yet to be arrested on the warrant. In this case, Your Honor, he has not been arrested. So that's probably why there is no address for him, because he hasn't been arrested.
But they still got somebody on the run.
Yes, he's been, my understanding since we started, he hadn't been in custody, and his whereabouts are unknown at this particular point in time.
Yes, Your Honor, he's the last defendant that has not been arrested.
Yeah.
And I have seen in his history on Odyssey that
It's still on the run.
he might have been returned to Washington State Prison. I checked their database, and he's not an inmate located there.
I don't believe we aren't showing that Mr. Cobb is in custody anywhere else, are we?
Correct. Oh.
No, Your Honor, not at this time, no.
All right, well,
Is on the run still. So they got one person.
unless and until he's before the court, then there's nothing we can do about Mr. Cobb's case. I would just say, stay ready. If he's brought into custody or whatever, then you start from there.
Will do, Your Honor. May I be excused?
Yes, sir. Have a good day.
Thank you, you too.
But, you did make a official entry of appearance, have you not?
I have.
Okay, thank you.
The guy that's on the run, been on the run for 2 years.
Mr. Mender?
And they haven't called him yet.
Nicole Payne on behalf of Mr. Mender, he has been delayed.
It's hard to run that long.
He is rejecting the plea at this time for the notice of trial conduct.
Okay. Ms. Jones, did you get that? No, I'm the court reporter. I was just making sure she got, I know who you are, ma'am. So.
Yes, Judge.
All right. Then we'll further notice the case to the trial calendar. All right.
Another case to the
And
trial calendar. I guess they going to trial.
next would be Mr. Winfrey, but I don't see Mr. Francis. Oh. All right, Mr. Francis has filed a leave of absence, and he's out of the country currently, and so. Yeah, briefly, go ahead.
Yeah, on the record, I would like to fire that counsel because he had legally corresponded with me, no type of way with this case. If you saying this is the final plea, and I ain't had one lawyer visit, I ain't got my discovery pack, so I would like to retain another counsel because I feel like I have been ineffective counsel by the lawyer visit.
You stated that you felt this lawyer was ineffective.
Never met with him.
Haven't received the discovery. Haven't got anything.
Yes, sir. That's true. Are you?
It's been 2 years.
Are you asking to be able to get someone else appointed, or are you saying that you have the resources or intend to hire private counsel?
I can hire a private counsel and retain another. I'd like to be appointed another counsel.
Okay, well, let me make sure we're on the same wavelength. What I'm asking is,
Do you want the?
our understanding was that you were indigent and not able to afford to hire an attorney. Okay, well, then the question isn't whether you can hire a private counsel or get someone appointed. It would be either you end up having to stay with Mr. Francis or you're able to get someone else. I understand what you are asking, and we'll take that up at a later date because we need to have him here to be able to hear from Mr. Francis, because he didn't, I guess he got appointed right before the last time we were in court. Was that not? I'm not arguing with you. Sir, I'm not disputing what you're saying right now, okay? I'm just saying I need to have him here so we can know the reason why if he hasn't been able to contact you or go forward with you. And unless and until we find out, we're not going to just give you another lawyer.
Well, I have my family retained when I want.
Well, you're free to do that at any time. You're free to do that.
You can hire a lawyer if you have a problem.
Okay, I hear you. I hear you, and I just said I'm not going to deal with that until we have an opportunity to have the attorney present.
Obviously, you don't have
Okay, I got you loud and clear, sir. Okay.
So what he should be doing
Okay, so Mr.
while he's in there.
Winfrey's remains open, which we would do because counsel isn't here anyway, and if we need to make a change, the court will look into that matter as to whether or not there's a justification for doing that or not. And in the meantime, Mr. Winfrey, if your family wants to hire counsel, then they're free to do that. There's nothing but air and between them doing that, but air and opportunity. And the air ain't gonna stop them, and opportunity is still there. So if that happens, then let them make an appearance, and then they can represent you going forward. All right. This is what's on the calendar. All right. Yes, you can.
Good morning again, Judge. Tianre Callen for Mr. Khalid Adams. I have conveyed that offer to Mr. Adams, and we are announcing ready for trial.
Okay, further notice to the trial calendar.
Thanks, Judge.
All right.
That concludes my business. May I be excused?
You may.
Thank you.
All right, if there's nothing further, then anything from the state?
No, we'll just proceed with the other defendants, and I guess when this one is ready for trial, we'll come over and handle these defendants.
All right.
Excuse, Your Honor.
You may. Have a good
Good to
day.
see you. You too, Your Honor.
He was going to trial.
Judge, before they leave, may I have the name of the ADA, please?
Sorry, Simone Hilton, Hylton.
Thank you.
You're welcome. Thank you, Ms. Jones.
All right, Ms. Jones, that's it. We're down.
All right, thank you, Judge. Have a good day.
Judge, I'm closing everything down. Have a good day.
Hey, man, the judge did the hearing on all the defendants. I don't think he got to all of them because a couple of them didn't have attorneys. But he did the hearing for the people that were separated with the YSL trial. The people that are going to trial separately from everybody else. And these people probably were, involved in some things in some of the situations with YSL, but they weren't the people directly in the circle. The people that were directly in the circle, those are the people that are on trial right now, because they are connected to being involved with Little Woody in the car, different situations where things happen. So those people are at the front of the trial. These people were just affiliates, associated. They might have been on the phone, had some phone calls, did some different things that was breaking the law. But they said they're not taking a plea. Everybody that's watching this YSL case sees that the case is out of whack. It's a lot of funny stuff going on. You can't say without a reasonable doubt that these guys are guilty. It's a lot of doubt. It's a lot of doubt in this situation. It's things that might implicate these guys of doing different things, but the things that the guy, Woody, Tick, that they said in these interrogations and sat down with the detectives, they not saying that now. They got a different story. So it's like, do you know if they're lying? Do you know if they're telling the truth? You just don't know. But what you do know is that Young Thug is on trial and these other guys is on trial with their life online for testimony from people that made statements that could be lying or they could be telling the truth, and the jury has to weigh on that. And I really don't feel that that's fair to anybody for a jury to weigh on would a person lied or if they told the truth when they told two different stories. Those type of situations, the evidence from those witnesses should be a no-go. Because you have to see in your feeling, you might make a wrong decision. You might say that they were guilty and they really weren't. But the evidence wasn't solid. Now, this is the games that's played inside the court. They want Thug so bad, they like, man, we gonna still push through. It's rolling the dice in this situation. It's just like rolling the dice. That's all they doing. Because they know they got a chance of losing. Do you think Young Thug has the ability to beat this case? Do you think he'll be free? He's been down 2 years now. And you get to sit there and reflect what you did wrong. So I know right now he's sick. You got to get up every day and go to court at 5:30 in the morning and sit over in this courthouse and let the prosecution explain to some people their case, and these people make a decision on your life. Involvement in the streets is always going to put you at a failure. You don't know when you're going to fail, but you're going to fail because it's the streets. It's a gamble. But leave a comment, man. Let me know what y'all feel about the situation. All the guys that said they're not taking no plea, they're going to trial. Let me know how y'all feel about that, man. Do y'all feel that they just did this now because they see the YSL cases all over the place? Or were they going to take the plea? Because these are the guys that case was separated, man. But leave a comment. Let me know how you feel, man. It's your boy DZ, man. It's not about the setback. It's about the get back. Nah.